Now let's put our hands together for Mr. Hirotaka Kamata, Principal Consultant Data Privacy of Internet Initiative Japan (IIJ). This session is empowered by TCC Technology Group in cooperation with Internet Initiative Japan. Everyone, please welcome Hirotaka-san.
Thank you very much. Good morning, everyone. My name is Hirotaka Kamata from Internet Initiative Japan, an internet service provider. Today, in this session, I'd like to give you a brief global overview of emerging privacy protection laws. And then I'd like to show you common basic principles that underlie all these emerging privacy protection regulations across the world. And then I'd like to show you how our cloud service offerings can help you comply and demonstrate your compliance with those emerging privacy laws in many different jurisdictions across the world. As you know, many countries are introducing privacy protection laws recently. Here in Thailand, your honorable representative just enacted new Personal Data Protection Act in May this year. It is very sophisticated legislation following the model of General Data Protection Regulation of the European Union. In Singapore, since 2012, a very strict privacy law is in force. In the state of California of the United States and in Brazil, they are enacting, they already enacted privacy laws, and next year, these new privacy laws will come into force. The government of India just introduced a very advanced privacy protection laws. All these emerging privacy regulations in many different jurisdictions pose a formidable challenge for global business. Suppose you are running global retail business with headquarters here in Bangkok and shops around the world located, say, in Singapore, Tokyo, San Francisco, Frankfurt, London, Paris. Then data moves around the world every day. Shops operating sends business data, sales data, including personal data of your customers, to the centralized backend system located in Bangkok data center. In circumstances like this, it's a big issue, challenge to comply with many different privacy protection laws in many different countries. Okay, so don't worry. The things are not very complicated as they initially seem. All these privacy regulations essentially consists of some basic principles or common rules. Oh, sorry, I forgot to turn the pages. Don't worry. All these emerging privacy regulations essentially consists of a few basic principles or common rules. These are lawfulness, transparency, fairness, risk management, and data protection across the border. I've explained in turn. Lawfulness means you have to demonstration that you satisfy certain legal conditions that legalize or make lawful your processing of customers or employees' personal data. Obviously, the most easy to understand example is consent from the person involved. But other than consent, you can rely on other lawful bases to process personal data. For example, if you deliver purchased item to your customers, it is necessary, processing is necessary to perform your contract with that customer. It is the necessity to perform the contract. It is one of the lawful basis of processing personal data. And you can process the payroll of your employee to calculate tax amount to be deducted. In this case, the processing is lawful because it is necessary to comply with your legal obligation you are subject to. And you can analyze feedback from your loyal customers to come up with a very precious insight that helps you to improve the quality of the service or products you provide. So these are the lawful basis. Next, transparency. It is very obvious. Transparency means you must explain what and how you do with the personal data you have. This obligation is typically discharged by privacy policy or privacy notice you publish on your website. Next comes fairness. Fairness means you must remain honest and process personal data just in the way you explain you do in the privacy policy. It's very simple, isn't it? And risk management means you must periodically assess the privacy risk involved in your business process and have in place proper security measures that is proportionate to the risk you found. So far, so good. These four principles are common in most privacy laws across the world. And if you follow these four principles very honestly, then you can, I will dare to say, you can remove maybe 70, 80% of compliance risk with privacy laws in any jurisdictions in the world. Sorry, let me drink water. Next comes a tougher one. Data protection beyond the border. Oh, it means ensuring data protection even after a personal data is transferred to other countries where the privacy laws of your country is not in effect. It sounds tough. Oh. Okay. Most privacy protection laws in the world provide for two lawful bases where you can lawfully transfer personal data of your customer or your employee to other countries. These are consent and certain legal framework. Consent is very obvious. All you have to do is to obtain consent from your customer or from your employee to transfer their personal data to other jurisdictions. And data protection contract or contractual framework is a little more complicated. If you protect personal data with a contract between that data exporter and data importer, such contract is generally called a data transfer agreement in many privacy laws. A typical data transfer agreement shall include common two clauses. These are obligatory data protection clause and third-party rights clause. Sounds complicated. And in an obligatory data protection clause, the data importer warrants and undertake that it will process the personal data in accordance with data protection laws of the country in which the data exporter is located or established. In third-party rights clause, the owner of the personal data, who is not party in the contract, can invoke the contract to enforce his or her right with personal data before the court of the country where the data exporter is located. I'm very sorry for legal complexity. So now, many of you may think that it is far easier to rely on consent when you transfer personal data to other countries. But here you have a trap, a very big trap. Consent is, by its nature, voluntary. In many jurisdictions across the world, consent can be revoked or withdrawn at any time by the person who gives it. What happens if your customer withdraw or revoke his or her consent? Suddenly, all your personal data processing becomes illegal or unlawful. So the consent is a very unstable, lawful ground when you transfer personal data across the border. Moreover, the General Data Protection Regulation of the European Union places consent as a derogation from the norm, which means you can rely on consent for cross-border transfer of personal data only in limited and very exceptional situations, like one-off, ad hoc, non-repetitive transfer. But for more routine, day-to-day, repetitive, a regular transfer of personal data, which is incorporated in your regular business practices, the GDPR requires more stable, lawful basis, that is, contractual frameworks. GDPR and other privacy laws, including Thailand's personal data protection law, prepare and provide for at least two common lawful grounds for cross-border transfer of personal data. These are the standard contractual clauses, or SCC, and binding corporate rules, or BCR. Now we look at the similarity and differences between these two legal framework, contractual framework, SCC and BCR. Both are essentially a contract between the parties. Both bind signing parties. And both include the two essential clauses I just mentioned, obligatory data protection clause and third-party right clause. So this is a common feature. And now we look at the difference between these two frameworks. Standard contractual clause is basically a bilateral contract between the data exporter and the data importer. On the other hand, the binding corporate rules, or BCR, are a set of rules that bind member entities of a corporate group or joint venture. There is a bigger difference. In BCR, certain accountability elements are included. Accountability elements set out in privacy laws, for example, GDPR, namely education to the employees, an audit mechanism, periodical review on data protection measures, or complaint handling mechanism. An important point is that all these accountability elements have to be reviewed and approved by relevant privacy protection authorities of each jurisdictions. Oh, sorry. Okay. So the process of BCR approval is a very lengthy and costly process. It usually takes more than 3 years to go through the process. Supervisory authorities of at least 2 member countries of the European Union have to review the accountability elements of the proposed set of BCR, and all the EU member states have a right to submit opinion to any proposed set of BCR. All this means that once approved, having a binding corporate rules approved by the European Union can be a golden seal of compliance with the strictest privacy law in the world. And this high level of privacy compliance is most likely to be a general compliance demonstration with privacy laws in most other jurisdictions across the world. Oh, sorry. Okay, now we will see how all this works in a typical situation of global business. Suppose you have a global retail business with headquarters in Bangkok and shops in Singapore, Tokyo, San Francisco, London, Frankfurt, Paris, or other key cities across the world. Data moves around the world. Shops transfer customer data every day to the centralized backend system located in Bangkok. In a circumstance like this, the easiest and most readily available way to legalize cross-border data transfer between the group entity is signing data transfer contracts in line with standard contractual clauses. But here comes a problem. If you have multiple entities involved, then you must sign a lot of documents. Here, we have 6 entities, and we must sign 15 documents. It's very complicated. But in reality, we can aggregate this data transfer agreement into a single aggregated agreement. So all you have to do is sign a single document. The actual and physical transfer of personal data takes place between the cloud services, cloud virtual servers located in each cities. Here, this is where we comes in to help you. And if the cloud service providers are involved in the international transfer of personal data, all the controller entities must have a data transfer agreement in line with SCC, with all these cloud service providers that are positioned as data processor in many privacy protection laws, including Thailand's Personal Data Protection Act and GDPR. The above, they are data controllers. Data controller is entities who decides purpose and means of how to process personal data. On the other hand, data processors are entities who process personal data under the instruction of data controllers on behalf of them. And to legalize data transfer of personal data, that involves data processors, data controllers have to enter into data transfer agreement with all these data processors like this. Data processing agreement or data transfer agreements. Data transfer agreements. It's very complicated, and again, you must sign a lot of legal documents. But if you engage a data processor cloud service provider with approved BCR, then all you have to do is if you engage a cloud service with approved set of binding corporate rules, then all you have to do is sign a single processing contract with any of the processor entries. For example, Leap Solutions Asia. The BCR-ready cloud can help you simplify the data transfer across the border. Moreover, the BCR-ready cloud can help you demonstrate your compliance with privacy laws in many different jurisdictions. In most countries, the privacy law provides that data controllers must have a legal obligation of properly supervise their data processors or engaged service providers. If you engage a data processor or cloud service provider with approved BCR, then it becomes far easier to demonstrate your compliance with your due diligence or supervisory responsibility in regard of the data processor. So now I would like to announce to you an important fact. We, IIJ Group, are in the final stage of approval process of binding corporate rules with the European Union. Maybe by the end of this year, we can announce you that we have our binding corporate rules finally approved by the European Union. Then, once approved, we will cover our whole cloud computing offerings with the BCR. We will begin with our headquarter, IIJ, and our 100% owned entities across the world. But soon after that, we will expand our coverage of global BCR to our joint venture partners in the key Asian countries, including Leap Solutions Asia, located in Bangkok, Thailand. So I hope we can help you demonstrate your compliance with BCR-ready cloud. We, IIJ, are doing consulting business. We help our customers to help comply with world privacy laws. We have many lawyers and professional consultants who are very familiar with many different privacy laws across the world, including the GDPR of European Union and Thailand's newly enacted data protection law. So if you have any trouble or if you would like to ask something, please consult with Leap Solutions Asia. And I hope we can help you before long. Thank you very much.
We open the floor for the questions. Please raise your hand if you have any questions. Okay.
Good morning. I have one simple question. I think regulations and laws are critical and important in the corporate world and in international trade. So can you help me understand, in view of all this regulation, how are we going to help young entrepreneurs in Thailand to develop their own version of cloud? Because you can't leave it, and I much appreciate all the big guys here, but I think there's also a need to continue to promote technology innovation in every country we go to. How do you think we can do that within these regulations?
I just introduced our example. So as you said, service provider has a vital role to promote the privacy compliance with the global business. And we, IIJ Group, have an education program to the young employees or partners to become familiar with the world privacy laws. As I said before, the privacy laws are very simple if you correctly understand it. As I said before, the privacy laws of most countries consists of essentially 3 or 4 basic concepts or rules. Lawfulness. Among them, the most important are the transparency and fairness. You should explain what you do with the personal data very honestly, and you have to remain honest to your explanation. If you educate that most important principle to the young people or young employees, maybe you can greatly improve the compliance level of your service or the young generation of your honorable country.
Okay, and I'd like to invite Jeannie to present the token of appreciation to the speaker.